5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on. This is not slavery. I'm not the one. I am not the one. I don't even have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to start now.
This defendant is facing felony retail fraud. Maximum exposure, 5 years in prison, and up to a $10,000 fine. And his first move at arraignment? Argue with the judge about whether he even has to answer to her, instead of handling the charge. He starts lecturing the court about slavery and claiming the legal system doesn't apply to him. On top of that, he can't decide whether he wants a lawyer or wants to represent himself. And that alone tells you where this is headed. If you were staring at 5 years, would you open by telling the judge you don't answer to her? Let's dive in.
25S00791. FYI, people say the Michigan versus Timothy Dance.
Secretary on behalf of people.
Illinois, P8746, Stephen in for the attorney of record, John Donald, and appearing on behalf of Mr. Dansley, who stands to my right. Mr. Dansley, can you please state the name for the record?
My name is Timothy Dansley, and I'm out to represent myself and take counsel as an assistant. You know, but I don't know who this being is. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery back.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's paying me hard. So I'm gonna need some type of system.
Okay, well that's what we got for you. Okay.
I'm gonna represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I wanna go ahead on with the
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge,
I believe it's 5 years.
yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
He says he wants to represent himself, but then he also says he wants a lawyer because he's not getting the paperwork he believes he deserves. That contradiction right there is exactly why self-representation is risky. You can't act as your own attorney while simultaneously asking for legal backup. Every time the process feels unfamiliar, court procedure is technical, discovery, arraignment, motion practice. Each stage has its own rules and timing. Arguing about discovery during an arraignment is like demanding the final exam before you've attended the first class. The judge can clearly see he doesn't understand the procedural posture of his own case. Confidence without comprehension is dangerous in a courtroom because the judge knows the rules. The prosecutor knows the rules. If you don't, you're the only one operating at a disadvantage.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Danby today, and have not received any audiovisual discovery from my understanding.
I like to be honest, if you don't mind. About emotion, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, and it's happening now, you know what I'm saying, and the prosecutor was conduct of receiving my discovery change, even though in my life.
Okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, y'all.
Sir.
Yeah.
Do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So in the first hearing, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just say, oh, yes, come on, this is not slavery. This is not it. This is not the one. I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
What's your likeness for?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't. You don't care. That's why you're here charged with something.
What is your life for?
I don't have to answer you, and I don't answer to you, and I'm not going to start now. You need to settle down. You need to settle down. Okay, take him out of here, please. That's okay. He's just having his moments.
Then he brings up slavery. In the middle of a retail fraud arraignment, that's not a legal defense. It's a rhetorical diversion, and judges are trained to separate emotional arguments from legally relevant ones. When a judge says something along the lines of, "You must not care about anything," that's courtroom language. What she's really signaling is, you are actively harming your own position. You don't resolve a shoplifting charge by rejecting the legitimacy of the entire system. Once someone decides the law doesn't apply to them, the outcome usually follows a predictable path. Because courts don't debate jurisdictional philosophy. At arraignment, they process cases.
So we're going to adjourn this, and I'm going to waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right. So we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give a couple weeks to do it.
Yes.
And he's going to want to see it. So you're probably going to need to have him take a laptop over there to the jail and take his license to practice law to it. Okay. All right. So the next probable cause conference on this charge is going to be.
All right. I just to make a record as regards to that discovery. I do have paper discovery, which counsel has noted that has been tendered already. I do not have. Does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Garnick will be in trial in the Wayne County Court. I make that paperwork for myself if you're wanting Mr. Garnick to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Garnick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance, I would be more comfortable with Mr. Garnick because he handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't
ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got Miss Gracie right. He's an expert in us.
I've had my share over the years when I was licensed to practice law. So, by his standards, I'm not licensed. Okay. Mm-hmm. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Garnick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
The judge gave him multiple chances to calm down and cooperate. She warned him about potential consequences. She told him to settle down. He chose to continue. There's a massive difference between asserting your rights and misunderstanding them. 5 years of potential incarceration is not the time to experiment with self-taught legal theories. Self-representation in a felony case requires deep knowledge of criminal procedure, evidence rules, and sentencing exposure. It's not something you improvise. So here's the real question. Would you ever represent yourself on a felony charge, or is that a risk no rational person should take? Drop your thoughts below. And if you enjoy courtroom breakdowns like this, make sure to like and subscribe. I'll see you in the next one.